notice it was.
What is the content?
The development authority.
What is the direction?
Direction is. No, I am for direction means only Supreme Court.
Where is the order?
Order means order. May I pray minus? Maybe taken up later and I don't have detailed filing by that is. We don't have detailed filing by this. What is in fact, I don't have detailed file. Orders have been quoted by Honorable Supreme Court in paragraph 4, paragraph 6. 6. 6. Original order model better in WTC. Better 24 to 2011. No. You can see para that order.
24?
24 to 2011. Or the order, WPC order.
Or no. Contempt.
Consent said. Where is the order?
Contempt order.
Not here.
Yes, sir.
It's not included.
Madam?
It is not included.
In your application, have you included?
I.
No. That's the original.
Original order dated. I have mentioned original order dated manner.
What is that? You have not.
I have not annexed. I have not annexed.
What kind of a
Only content petition that arose out of the
That is
content. Order 278, the 12, that is original content petition. Then after my content petition dismissed, I have already whatever dismissed due to default. Thereafter, I am charging that fine SLP.
No. This position. Petition.
Super.
G category plot, you have to carve down. Why you have not done it?
I will give you detail minus I will kind text it, I will give detail, but before that, once I'm submitting 2 lines only. Fact means there was a direction to consider the applications in the sense.
Not consider the application, sir.
Yes.
The direction is,
Yes.
in view of the above, we dispose of the matter.
Yes.
We, with the direction to take necessary action against the allottees who have not yet started construction over the plot allotted to
That is
them.
relating to my.
And thereafter allot the same to a eligible person in accordance with law. It is further directed that the CDA shall proceed with the proposal for requesting the revenue authority
Yes.
as about to obtain some additional land for the
Yes.
purpose of carving out the plots to cater the need of the eligible person, including the physically
Yes,
handicapped
ma'am.
person, which includes petitioner
Mm.
for allotment of G category plots.
Yes, ma'am.
What you have done?
May I submit one?
No consideration.
No, thing is that not consideration, in that instance, I am not submitting matters. Thing is that we requested the government to grant it, give the land. First, right, number one, but in fact, the government is in handicap position because all the total land matters, part of the land has been given to National Law
But you
University.
did not challenge the order and there is
No,
no
that is not the thing. The thing is that kind of challenge, man. And I think I will appreciate it. A portion of the land matters, sector 13, and that was given to National Law University, it is the decision of the government, Ravenshaw College. So land matters have become scarce. For that purpose, we have gone for cancellation and most of them have undertaken construction. What in fact, what happened? We have carved out 30 acres of land for High Court, Honorable High Court. Honorable High Court released a portion of the land matters to 10 acres kept, 20 acres released. That is what we adjusted. Then we carved out some plots. We required him to participate in the lottery because we cannot allot it in accordance, except in accordance with law. He has not acted upon that. He has not applied for. That is
Why
what I'm
High
bringing.
Court released the 20 acres, 28 acres?
20 acres we managed, arranged.
How the High Court released it when it was allotted?
That has been communicated and it is as per the decision of the Honorable High Court and the government. 30 acres we have kept for government, the Honorable High Court. 10 acres Honorable High Court kept. 20 acres was released. That is what we adjusted into the because it is adjoining the. I will bring. But when we carved out 50 G category plot and F category plot, we requested you apply for and participate. Or sir, that is what also this is directed.
Affidavit.
Yes,
Your affidavit.
yes, ma'am.
Let the affidavit. The immediate application be filed.
Item 2, may I please Lordship. Yeah, Lordship, annexus 6 is annexus 6 is Lordship, page is 81 to 83 Lordship. Here's what happened Lordship in this case.
81.
81 to 83, annexus 6 is the interim order.
Single bench order.
Lordship, single bench.
Right? You are.
And
How you can file a contempt?
No, it is a contempt appeal, Lordship. It is a contempt appeal against the order of the Honorable Single Judge. Where the annexus 6 is.
Yes.
Lordship. Here, Lordship, the case is that annexus 6 is the order where the petitioner is before Lordship. Honorable Single Judge were dealing with the conflict petition, as in pleased to dispose of the conflict petition, saying that there is no material to show the disobedience of the order also. That is what the observation by the Honorable Single Judge. Here is a case, Lordship. Kindly see the order passed in the original deed application. That is at page 65.
Was the order?
Lordship, page 63, Lordship. On page 63 and 64 is the relevant page, where this Honorable Single Judge has been pleased to pass the order. And that was not been compared with Lordship.
To vacate the encroachers in
Lots.
the house of the.
Lots. Lots.
Lots.
That is the order only passed. Thereafter, what happened, he approached the concerned commissioner of the municipality.
Whatever.
What is
Where is your contempt application?
Let's see, there after
Where is your contempt?
content application starts from page 72. Let's see. Turning page 72. Let's see. There we have added how they are not.
Just let us see.
Let's see.
Where is the contempt?
Content is, let's see.
Where is the contempt? There were two unauthorized shops, they have demolished already. There was some Pakka structures, there they have shown certain documents that they have been given. A particular LRC, that is a land record
Yes.
certificate has been given in their favor.
Right, let's see.
Then the government said, I can't. Once they show their rights,
Right.
you say that is in respect of stipulated plots. Now you are creating a confusion with regard to that plot number.
Right.
Now, once there is a confusion,
That's it.
will the contempt lie? I'm saying.
That's I'm grateful on that point also. But
There should be a clarity,
Clarity.
there should be a willful and deliberate and conscious violation.
Exactly.
Mere violation does not tantamount to a contemptuous act. It should be a willful, deliberate and conscious.
Yes, that's
If they have raised a debatable point, will the contempt lie? I'm asking you.
that's it. I'm answering that's it. Before that,
My own judgment is staring at my face.
let's see. I'm never done. I mean, lordship. Here, lordship, the case where basing upon that order or path of the report, the concerned RI, they made a fill and crime. Which is
Everything, and you are in contempt jurisdiction. You are not arguing a writ petition independently. Bear in mind.
right.
Yes. And that is what you should bear in mind.
Lordship, I'm trying to. Thereafter, the NK report says, the RI consent report says that the consent plot has been enclosed by some enclosures. There they have made some adjacent house and soft rooms. That was the report. Based upon that, they went to the spot and made eviction of two soft rooms. Rest they left. Why they left? They gave a reason that when we were on the process of the eviction, then they produced some LRC, which shows that they have some documents in their favor. That is what they say. Now what happened? They submitted the document which shows that
Can contempt court go into that disputed aspect? I'm simply asking this question.
let's say when the authority has not acted upon in accordance with the recourse order, that is how the question handles.
Sorry. The contempt application filed by the
Item number 3.
Item number 3, may I please, my lords? I may be permitted to appear through virtual mode, my lords. My lords, this is a contempt application. Your lordship may come to running page number 12, my lords. That is the order, and operating portion starts at running page number 13. Last paragraph. And my lords, on the last occasion, notice was issued, my lords, on by order dated 6/4/2026.
Have you disposed of the matter within 3 months?
My lord, I have received, yes. They have in fact passed an order.
Who are you? You are for the arrest contempt now?
Yes.
There was a direction to dispose of the application, annexure 7 within 3 months.
May I,
Have you,
may I pass on some documents?
what documents? Sir? You
One
are
is,
complaint counsel with the right.
Yes.
It's not a normal proceedings.
Yes.
The document is handed over.
Here, my lord, what has happened, the case was disposed of without notice, so the annexure 7 was not available. Thereafter, we wrote a letter on 10 January 2025.
Sir, what not available means the copy of the writ petition was served upon the government advocate or for the department.
No, my lord, here it is NNC, different company.
Never was the company, no.
He was served with a copy of the contempt application.
Yes,
So
So-
he knew that annexure 7 is there.
yes, my lord,
When the order says annexure 7 is to be considered,
we have.
why you say unavailability?
No, no,
of
at
the- of
at
the-
that
of
point
the
of time,
application or
at that point of time, madam, I'm sorry, I'm not.
I am
able to-
talking post the
Yes.
order. I do not know.
Yes.
Do not want the history of the litigation.
Before,
Tell me post.
before that, on 20th of February 2025, the order has already been, annexure 7 has already been dealt with. But after receipt of the contempt application, since no communication, the proof of communication was available, so on that basis, on the available email address, it has been again sent on 24th April 2023. So this has been already disposed of on 20th of February 2025.
So it was
Let it
within 3
available.
months. It was within 3 months.
Yes,
Only the communication could
Yes,
not be made.
only
within 2
communication,
months.
yes.
2 weeks.
yes.
Say in a very simple sentence.
Right. Only communication part is that is why
Now you have communicated.
now what we have done, Miller, because of the urgency, they have communicated through email with a copy mark to me.
Why you did not on this now? How you got the email address subsequently?
So I don't know, Miller, but they have just
You say
given.
that
We will-
not
we will-
available.
we will-
Now it is available. How you got it?
We will give we will again send it by speed post. If
No, I
they are
am
not-
asking. Sir. Why you did not embark
Then.
That's it.
then-
by giving a speed post?
We are sorry, Miller. Sorry.
Sorry, Phil.
I'm extremely, in fact, they communicate.
The task.
I do.
No, you are not to be sorry. My lord is asking you that if the email address was available with you, what prevented you not to communicate then?
Earlier.
Yeah.
Within the time, not earlier. Within the
Yes,
time.
within. Yes. Only-
Why?
I will file an affidavit if you are also.
What happened?
I will take
What
further
happened?
inspection why this was adopted.
And if the explanation is not satisfactory.
Lords, may I be permitted, my lords, in the last line also of that order, the communication was also supposed to be made, if your lordship comes to the last line of
What
the
you
order.
heard, he is saying so. He's saying so far as a 3 months period, I have complied, but communication 2 weeks, there is a fault.
Yes.
My lords. So far as,
What do you want?
oh, my lords, so far as communication, the order is clear to that extent as well, my lords.
That's true.
Yeah.
Last 2 lines, my lords. Last 2 lines.
No, that is why he said that.
Where is the communication letter?
No.
That is the first one, Miller. We are sought for annexure 7 because it was not available with us. The second page is Miller. Later.
There is an order,
Miller, this one,
the letter which was issued.
this is the letter, Miller.
This is a letter you have simply closed.
We have replied it to annexure 7. Annexure 7 was the representation. We have replied to the representation.
No. Who is this Ratwan? He is the person.
Yes, he is the person.
You have already communicated. Yes. And when the contempt is filed,
Alerts. 9/1/2026. 9/1/2026.
yes. fact has been done. I say na.
My lords, may I just pray one thing, my lords? My lords, liberty may be granted to challenge that order, my lords.
Sir, you are a senior lawyer. You know what is why. Why we have recorded that the service has been affected today.
My lords. Grateful, my lords.
Item 4.
On the last posting date, state was directed to take instruction from the matter while the order has not been completed till now.
Still in the diary number? Who has gone to the Supreme Court?
This is the.
No. You have gone to the Supreme Court. There.
Who has?
Have you gone?
No, my
Then why compliance is
My
not?
lord, regarding compliance, my lord, the proposal has been made to file a review application against the order by the government review. That proposal I have received. So far as the single judge order, if your lordship, that in fact that is not a part of record. My learned friend is essentially claiming compliance of the order, single judge order.
Oh,
Single judge order is not a part of record. It is not enclosed to the.
how the contempt lies to the division bench. The division bench simply dismiss the appeal. Nothing more than
Directing
that.
the single judge.
Then why the contempt lies to the division bench? Have you got the full bench decision authored by me?
My lord, already I have filed
Which
Have
one?
you?
single bench decision.
No.
Full bench.
No, you did not probably hear. Lordship. The question is that the division bench has simply dismissed the writ appeal. Thereby, the order of the single judge is to be complied. So why the contempt is in division bench?
I'm asking this question. How the contempt lies to the division? Have you got that three-judge bench decision of the Calcutta High Court where the contempt lies? Me, Justice Sampasarkar and Justice Kaushik Chandra, if I correctly remember.
The order will be given. So being the single judge. will be given.
Running petition was told the contempt petition. Last paragraph. In the above circumstances, this appeal fails.
Fails. Yes, only the extension of time, that's all. Does it mean that the contempt application would lie to a division bench?
Just one line more. The impugned order of the learned single judge
Shall be complied with. I know, I have seen. Does it mean that it will lie to a division bench? I am asking. It's the affirmation of the trial court's order or a single judge order. That's all. Where the appeal with content would lie? Go there. Why you are finding it here in the division bench? Have you got?
Final permission.
I don't know. which does not lie. Or dismiss. What is the date of the order? Single bench. 80-24. And what is the division bench? So 73. Or 26. The case that there is this order is called. Unable to find out. Find out from a contempt of courts. Anyhow,
Item number 5.
Keep that here also.
Yes.
And give one copy to my brother also. This thing. Item number? Five. Okay, what is the contempt, sir?
Division means WA order.
This is a case of modification.
Starts from modification.
Have you? No medical test was directed? No. Into order of the extent prescribing a fresh medical test is modified to the effect there shall be no need for the appellate letter going anywhere. So
It has been upheld last time notice was issued. I have instruction to appear, but I have not received the Vaklaatnama as of yet. However, I have taken the instruction, Your Lordship. Selfie has been preferred against the order that has been passed by the division bench. And the SLP number, which is on filed on 1/7/20.
diary number or SLP number?
Diary number.
Tell me SLP number.
Yes, I have only today want.
Why defect? Why defect?
In the morning, I have taken the instruction over telephone, so
After notice, the LS contemners. Contemners or contemner?
Contemner.
Two contemner.
Here the listener was opted because of licensing.
Yes.
He had challenged two letters. One letter, the letter of the commissioner directing super excise to collect a transport fee on the local purchase of Magua flour within the limit prescribed under Rule 4. Rule 4 says the prescribed limit of local purchase is 2 quintals. 2 quintals. So here I have purchased also, it is 3 years they have issued a demand under Annexure 7 at page 35. They are saying that you have not paid transport fee for the year 22-23 to 24-25. I have given Annexure 3 have local purchase. Right.
Please give me a page number. You know, you are appearing frequently.
At page 5. Annexure 5, page 32, sorry. Annexure 5, page 32.
Yes.
The local purchase I have given, it is shown. But here they have not issued any show cause notice or nothing. They have straightway said that you have not paid as per the letter of the commissioner to collect the transport fee on Mahaflower. They have given. There is a similar point also raised to the file and lordships have considered and the lordships have granted also. Because there is a decision of this on court that if it is a prescribed limit within the limit, there is local persons, there will be no transport fee because there is no transport. Because basing on the decision of this on court, WPC 14493 of 2004. It has been written.
So say the committee of judicial discipline commands this. Yes.
But what he is submitting that if the purchase is within the limit within 2 quintals, then there will not be any transport.
So he says I am within the limit.
No, in the present case, he has not submitted the form which is a required form. He is to fill up from whom he has purchased. So that can be inquired into and how much he has purchased, that has also to be verified.
Correct.
But that form has not filled up and he has submitted. Therefore, on inspection, they found this much of quantity there.
So why don't you give them
Space 30.
30?
Verification of the OIC
30?
but
30?
Page 33 of the writ petition. Page 33 of the writ petition. Now the stock is 32 and 33. Physically verified
Verify
the
this
stock
stock.
of mohawk flower, go down and found so and so quintals of mohawk flower.
See, incomplete.
So they have not stated
No, no.
that you have not submitted the name and address of the.
Where is
How that comes
where
in
is
the
a
writ petition?
requirement under the statute that they have to submit a form?
No, there is no form.
All I am asking him, sir, he is saying here you have not submitted a form.
That's it.
I am asking where is a provision in the statute which requires?
Rule 4. Okay.
Yes, rule 4,
Rule 4 of the Orissa Excise Rule 2017.
17, yes. What it prescribes, sir? Yes. This is the interstate transfer.
Yes.
Tell me,
So it is also not known from whom he has received. No,
sir, the verification has come and therefore the name of the address of the permit or a licensee holder from whom the Maua flowers under such and such is purchased.
Yes.
The column is there at page 32. He has given a name.
no, this is incomplete.
And what are you talking in the next page on this register? You have said verified the stock.
So they also can refer to the date. There is only one date, 16/4/2024. And another is 17/4. Then there is nothing. There are,
Sir, 18/4 they have not purchased. What they will do every day they have shown. Then what more? If they have not purchased any Maua flower in those days, why they will put it in register?
the quantity we have ascertained.
The quantity that is given.
No, that is the less quantity they have told.
So,
Quantity
So-
4,163 quintals.
from where you got it
Yeah.
during that period? And where is the provision for uploading this?
And 4,579.
Every application for issue of the pass. The pass was issued.
No, not required.
Pass is
The
not
rules
required.
for proviso. That's
Proviso is not required.
Yes.
Sir.
Provided that
Parcel will require
for
that
proviso.
quantity does not exceed the limit is specified in the table. Maua flower. Okay. Disputed question of fact.
No, they have not produced, they have not submitted the form.
Sir, where is the provision for a form? I am asking you, sir.
Then the form B, rule 4.
Where is that?
Rule 4. On verification of the stock of accounts with the Mohawk flower in form number Mohawk flower B, the petitioner has not mentioned the detailed address of local individuals from whom the petitioner was purchasing Mohawk flower for display.
Then why 30? Sir, that belied this particular statement where you have made an endorsement. You have made an endorsement.
Yes,
So,
that endorsement is not part of the form he has submitted, not
We are not every year, after completion of year, we are giving that register to them. The register with them. There are 3 years, 22, 23, 23, 24 and 24, 25.
No,
All the years after completion of year, we are submitting the register. The register with them. Let them produce.
I think
That
that is where we should. Sorry.
Yes, submitted will produce.
We'll pass the same order, stay the demand.
According to the register showing that he has not submitted the form, unless he submitted the form, then he is liable to pay.
With
the
Mr.
fine.
Soy, with all respect and the humility to my command, I have been breaking my head to find out where is a provision for a form to be submitted in all such cases in case of purchase.
That is in the policy, I think that
I just wanted to know, you are saying rule 4 does not say, it says no pass is necessary for the for transportation of mahua flower up to 2 quintals. They say that we are within that purview. Now this is essentially a disputed question of fact.
Not disputed, I produce the register and also form, the required form B, also produce. That is not in the transfer, therefore I am difficult to immediately.
So we are staying the demand.
So, let's not keep it to Monday.
No, staying the same order.
Is it loss of use quantity of amount?
Maybe.
Is it?
Yeah, we are passing the same order. Cannot be done in this way. And also record the counter affidavit filed by the opposite party be taken on record. Rejoinder may be filed within a week.
Annexure 7, sir.
Impugn demand.
Annexure-
Yes. Whatever annexure 7, annexure 4.
That's it. In the order I have supplied, there also annexure 7 is there.
Yes. Next.
Item number 7.
Okay.
Request for an adjournment of the my license of file.
2 weeks.
Next.
Item number 8.
Legal finger.
Lord, here one of the petitioners did
Where is a letter dated 19/7/25 page?
32. Petitioners grievance.
Just a minute, let me hint. You want the refund of
I
EMD?
am for the refund of payment.
Where is, who is for the state?
I'm not asking about for.
I understand, sir. After looking at it, I could make out of what you want to say. Oh,
He has suppressed the material fact, therefore you.
it's not a suppression.
Not.
It's not.
Please,
it's
you
not-
cannot impute or incorporate. You say that his application is rejected as he has submitted an incomplete application.
He also tell his own.
Please come to page 32, last paragraph.
Own arguments he has.
I am asking you, sir, I am reminding you of MS Gill judgment of the Supreme Court. You can't improve a case at the bar. What your authority? Your authority, last paragraph, come. What he says at page 32. Please read.
Arjun's claim for refund of the EMD by you. I am informed that as per supervisor provision in para 3.
Sir, not the last paragraph when I am asking you, sir.
I'm reading.
Please oblige the bench.
Yes.
Please read.
In view of the above stipulated provision, without argument. Likewise, as per para 3 BI G of the notification.
Sir.
If during the preliminary scrutiny or subsequently. it is-
Sir, I am asking you, sir, the reason.
The reason is-
They are the powers which is given to you for rejection.
Yes.
I am asking you what is the ground of rejection.
That their permission is due to incomplete application.
Correct. That's all. There is no suppression as you said. There is no question of suppression. There is a difference between a the manufactured document or a fake document being submitted, and in incomplete application that they did not furnish many documents which are required.
The question was put.
Now, that is why you say that you will not refund the EMD. Now, you have referred certain documents, certain letters. In paragraph 2,
Yes.
you have said, as per the stipulated provision in paragraph such and such of the sale notice, such and such, the deposited application fee is not non-refundable. He is not asking for a application fees. Forget this. Then you take in the second paragraph, likewise, as per para 3 Roman 16 G of the notification, if during the preliminary scrutiny or subsequently it is found that the applicant has not paid requisite application fee or has not deposited EMD or has submitted incomplete application form or incorrect document of his application is liable for rejection, the EMD, if deposited, will be forfeited in such case. Can you show me this paragraph 316G? Have you?
Page 14.
Page?
Page 14.
One.
Page 14, paragraph 9.
No, that is not 9 actually, that is G. Page 14, my lord.
Page 14.
Paragraph 16, G, that is by mistake written 9, my lord, that is G. That you lost in the.
No, I understood.
That has been referred, that exact para has been quoted.
So in that event, what to do? EMD?
7,94,000 deposit. I
What?
was not able to participate in the lottery also.
No, that's true, but
Mistake, my lord. What
but it is a incomplete.
My lord,
Have they intimated you?
I the application, I paid the application fee, EMD and all.
What incomplete means?
But
What you have?
incomplete, I am just referring page 23, lordship. They are referring to this clause.
Yes, please.
Page 23 of the application form, annexure 2.
Yes.
They are just below the tabulation, my lord. There is a question asked, have you received any license from Excise Department, Odisha in the past? If yes, kindly provide Excise no due certificate mandatory. There he has written by mistakenly no, but it should have been yes,
Yes.
because the reason they have cited in the rejection manual page 25 and also earlier he was having the licenses of Karangia, Daspur, Singra, Jamdasi, and the Sarupalli that has been put to auction, my lord. So when all these my lord, shops he was not running at the time during the time of filing of the application form. There were no dues also remaining. So my lords, unless my lords, if there is no dues or if there is an area dues also remaining, I will not be able to surrender the licenses. Admittedly, I was not having any of those licenses running.
No, sir. This is a conscious because is there any condition that somebody who does not have any license in the past will be considered or given a privilege?
I am not on that, my lord. Only they have rejected my application because I have stated no.
No.
That's the,
no. Second, did you submit the certificate? No due certificate?
That I could not submit because
I would have gone in your favor if you submit that no due certificate and inadvertently say no.
That effect, man, I have also represented before collector and stated in the averment, my lord, there was a bona fide belief of part of the petitioner that because I was not having any licenses running during the time of the application, during the submitting the application, that is why I have written no, my lord. So that was not suppression, my lord. That was bona fide mistake coming from the part. Fairly, my lord, that is the only ground, my lord.
You know it very well. No. If you would have submitted, you know consciously. I am again saying that due to bona fide mistake, you have said no, but actually you wanted to say yes and you have submitted the document also, certificate. I would have understood bona fide mistake on your part. No.
Well, I have all the notice certificate.
In that case, the document
Maybe.
spoken in others.
No.
Well, around 8 lakhs, my lord, I have.
What happened?
My lord, may be permitted, there is a clause, my lords, in the sale notice itself under page 16, my lordship.
Yes, sure.
Under sub clause U, my lords.
Yes.
My lords, may be permitted to move before the excise commissioner, my lords, here be.
This is in relation to on account of lottery.
Dispute, my lord.
Only on lottery.
My lord,
No,
may-
no.
Other case,
That it was not conducted fairly, then I can understand. No.
my lord, that was the only, I have
But that
submitted.
is not your grievance. That is not your grievance.
My lord, I-
That is not your grievance.
my lord,
And this is a second rejection. That is the second rejection.
my lord, the
Earlier rejection was in 25. Again you find.
Well, in 25, that has been passed to the superintendent of excise.
Whatever.
So, my lord, above him, my lord, there is a collector and excise commissioner also. Kaushik. And in other cases, other instances are there where similar instances.
There was 21/6 June letter which was ground of rejection was already given to you.
Well, there are similar instances where excise commissioner has allowed in these circumstances while representing.
Make out a case.
I can, my lord,
Then what you were doing at the time of drafting, if you know,
subsequently now I
then you ought to have said that there are certain information which I received.
the circumstances.
Always it is.
Excise commissioner has allowed, my lord, in certain cases in foreign liquor auction sales.
I was there for 19 years. I know all the. You have not completed that year. That's true. Idiot. Withdraw.
Item number 10.
This is a matter once had traveled to this honorable court when the lordship's order is there. Question of surrender of a license. You will kindly see before I take anything, lordship will see your lordship's order at page 62. The surrender application was rejected earlier on the ground that the new policy has not come and the duties were not paid. In fact, your lordship has taken note of the fact that duties were paid in the meantime. Considering that, your lordship passed the order, page 62, your lordship may see.
Then what happened?
Now kindly see annexure 1. Now he says, the London collector after the lordship order says that
Annexure
annexure 1 page 30. Page 30. Kindly see page 30, last paragraph. Bottom paragraph. In pursuance of letter dated 26/3/26, Excise Department Excise Commissioner has instructed to deposit proportionate application fee, level registration fee, and 2 months advance.
Where you are reading?
Look, page 13
In the bottom.
at the bottom of this book.
Oh, yes.
Precisely, he says that the 25-26 license period is extended since you have not applied for extension and your license is not valid. Surrender
That
application.
was an automatic extension by them.
License clerk definitely have applied for surrender.
Huh, I
So
understand.
there is no requirement of extending. You can't compel me to extend it.
Huh.
Now he says that since you did not avail extension,
This cannot be a
how
ground.
can it be? You kindly see the preposterous reasonings given.
Sir, a person who is unwilling to continue, and if he has done, why you will force him to continue?
And I'm a defaulter, my guarantee be invoked. So I will be considered.
What kind of a thing is this? And our judgment was very categorical.
Yes, your lordship, in para 11 of the judgment,
Yes,
lordship, that is at page 65.
yes, yes.
Page 65, para 11.
Has not come into the force. Existing law continues to govern the field. Therefore,
It can
the
reasonably
whatever amount which is there for that period that is there.
Right.
So
continues to govern the field, and therefore whatever.
now thereafter you made a new policy, and next at that point of time it was not there. Extension was done.
Page para 13, if your lordship may kindness.
Erroneous and spacious ground
Yes.
caused and set aside. Reconsider the application afresh.
He will also take into account the lifting of shortfall of MGQ and payment of all statutory dues. If
Correct.
so, what
That is for that particular year.
We have paid it.
So he says that he has paid the entire thing.
That's not disputed.
and come back to it.
What is the you can't force him.
Take it.
Next week to take instruction. Otherwise,
Item 11.
My lord, I am an allegation against to open number 4, my lord. The collect,
why chasing him?
my lord, though I got the lottery in the year 2017, but the collector has allotted a IMF also to another person. Then I made an objection in which his license was cancelled, and the Excise Commission directed me for providing reallotment of time in my favor. Till today, my lord, I have been passing my days without getting license.
So what you were doing for such a long time?
My lord,
When it was cancelled?
my lord, 2017 the lottery was brought.
It was allotted to somebody else
My lord.
despite you. When they cancelled
My lord, 2018, my lord.
18, then what
My
you were
lord,
doing
I-
from 2018? What you were doing from 2018, I am asking you.
I have been trying to draw the attention of the authorities, my lord.
Where are those
My lord,
drawing of the attention? Why you did not approach the court
my lord,
immediately?
I also approached my lord once.
After 7 years, why you are approaching, or 6 years for the first time?
I have also approached to before this honorable court in the year 2019.
Where is that?
Well, that order I have not annexed to, but
Oh, not annexed. Where you have said?
my lord, I have stated my.
Where?
My lord, page 8, my lord,
What you have said?
my lord, though the petitioner also submitted the order of this honorable court before Excise Commissioner, but the Excise Commissioner remained silent to comply the order of the honorable court. The petitioner once again approved this honorable court by filing notification number 20,73023. This honorable disposed the same on 6/7/2000 by directing to the collector of Balasore for considerable grievance of the petitioner.
So then what happened
Till
2020?
today, my lord, no appeals.
Yes, what you have done? He's I think more benevolent to you in not filing the contempt.
But he didn't answer, my lord, why he sat over the matter from 2000.
Sir, he approached in 2019. He approved in 2023.
But 2019, he never approved the affiliate. That is what he said, but that he has approved, but no.
Sir, in
document on record
2023 matter, the court has directed you to take a decision. Why you are not taking a decision till now?
My lord, once the excise policy for 24,
I am simply,
25,
will you not
25
record and communicate the decision?
that I.
If the court has directed you to consider, then why you will not consider?
The court, I'll find out.
Take instruction next week.
You also find that 11/6/19 order? What was the order?
You produce that orders, everything on the next day.
Item 12.
The petitioner challenges the license granted in favor of opposite bid number 5.
Why you are challenging,
Because
sir?
there is a clear violation of section, rule 51(1)(c). Because there is joint family property. A joint family property, the present petitioner has the legal original, sorry.
What?
It is joint family property. Joint family property.
Whose joint family property?
The property belongs to joint family. So
That property means where they are setting up.
Set up the shop and he has got the license.
Hmm.
So he had when he applied for this license, we objected. We said that no, we do not.
Who are you?
We are one of the co-owners. Co-persons. So up to co-persons, we objected to it. No, because he has occupied the entire building. That is the reason we said that no, we are not. Please.
Yes.
He has occupied the entire premises.
He is also a co-partner.
He is also co-partner.
Okay.
He is also co-partner.
Correct.
But without obtaining our permission, we need to be
Where is the provision?
You can see 51(1)(c). You can also see. Rule 51.
Yes, sir.
Rule 51, page. Rule 51 of the Orissa Excise Rules.
I know.
Yes.
2017. Which one?
Evidence regarding ownership of the land and building.
Correct.
And C, where there is no such agreement, the written or willingness of the land or house owner to execute a registered agreement in the event of grant of license by the state government.
That means only as a tenant.
As a tenant also, but
She is a tenant. She relates to a tenant.
She relates to a tenant, but the house owner's permit is also necessary because
Correct.
all our house.
I know, I understand. I will be reminding you of two judgments of the Supreme Court against you. Sriram Pasricha's judgment and Kanta Goyal.
But here, my
what it says.
But let's kindly see the rules, the consumption format also. The form, the statutory form. That is at
show us
the 15. This is form 11B. 11B.
11B.
B for form.
No, I
that is form 11B.
Yes,
This is
just one.
in accordance with 51(1).
11A and B, yes.
Relevant page is 191.
I got it. Then what it says, sir?
15.
15. Do not belong to the applicant.
Belong to the applicant where the land and building owner is willing to give the house on hire lease through registered agreement.
Sir, that's why I say Sriram Pasricha.
Yes, Ballot, my understanding is that the next page ballot is the other format. The objection. And next page 194. Paragraph.
Co-personal property is that in every
would have been different. Or even you would have got him the partition also, it would have been different. But here is only one of
Where is
the.
the judgment of Sri Ramakrishna? In late 50s or 60s.
The,
Kanta Goyal.
and the
So, you know the law.
my lord, I know, I am conscious of that.
So,
I'm
there are two
conscious
aspects which
owner has not.
which you have said. One is he is admittedly a co-partner or the co-owner of the property. Second thing is he is in exclusive possession of the fund.
No, not to be, but he's in
His
exclusive
position may be
No,
in on behalf of his share as well as on behalf of the other co-sharer. But his position cannot be disputed unless there is a decree for partition by meets and bounds, and then he is required to revert back.
as per not sure,
That's a very
as per law,
fundamental
each
principle of
co-partner
private
is deemed
property.
to be in possession of the any part of the land, any part of the property.
Even in the full part of the land, in excess to his share
So,
in the property, he can.
previously he had got the license with the consent of the co-owners. With the consent of the co-owners, he had got the license. But that now because
Bitter relation has.
no, not return relation. To actually we need the property. Absolutely need the property.
Where is that?
Well, that judgment is that AIR 1976.
The Rampasricha,
Yes, Mr.
and there is another judgment of Kanta Goyal.
But in this case, the shop has been running since 26 years.
Oh, I understand, sir. When the senior counsel said I could imagine what is that. He is denying no bitter relationship, but I understand.
No, but actually they need
How to happen?
they
In a
need
very
the
natural
property.
phenomenon.
Absolutely, they need the property. All the co-sharers they want.
You go for a partition.
Look, that partition.
You go for a partition. Get the property divided by meets and bounds.
Partition.
No problem.
Partition because all the co-owners are ready to settle and now they will have the property. Man, because of this shop pilot, now they are not able to do anything and they have the pensioners are staying in rented property.
There is no difficulty, sir.
Rented property.
So no difficulty, sir. There is no difficulty. You can have it done.
The partition, they can, but the thing is the partition, certainly he will not agree for partition suit has to be filed and it will take years together
Sir,
to
that
take a
is not
decision.
there. If the shares are not disputed, you can go for a preliminary degree immediately. And immediately thereafter, the partial commissioner is to be appointed. He will just file a report whether it is feasible or not feasible.
That process also will
If
take
it is
more
not
than
feasible, section 4.
for that process only will take more than 10 years. But how is that?
Why?
When we objected to it, how it could grant license that only objected to it. Because as per law,
Means proximity.
77.
Both.
the law is very clear, right? Law is very clear that one co-partner deemed to be in possession of the property.
That is what is the law, fundamental principles.
Fundamental.
Every co-partners or a co-owner have got a joint right in respect of every molecule of the property.
That is the settled law. Whether Kathakal or any judgment, that is the law is settled. That is the fundamental principle
That
of.
was the case where the eviction suit was filed by one of the co-sharers. And a plea was taken that the other co-owners or the co-sharers have not been implicated as a party. The Supreme Court has said he has absolute right. He can continue. There is no difficulty.
And they have relied on Sri Ram procedure judgment, Pariksha judgment.
Yes.
Item 13.
I think I'll affidavit. After filing of the petition, some documents are there to be submitted to the affidavit. And some developments have been made. Affidavit by the council for the petitioner that subsequent.
Converse point to that of item number 8.
What?
Reverse the item number 8, whatever was the fault there, here it is just opposing that. Opposite.
It was item number 8, I forgot.
Item number 8 is he did not disclose that he is having a license.
Oh,
Accordingly, application was.
No.
No. Here also he did have a license, but he said no. His application is treated to a valid. Kindly see page 12.
Now we got a good evidence. Yes, Mr. Swine, you were opposing?
No,
So, this is one judicially noticed evidence.
This will check the.
Yes.
This will check the instruction has to be taken.
Yes. And it's, in fact, I've got some verbal.
Get Mr. Swine also to be there in the matter. Both of you. When I have directed that matter to be discussed.
Next week on 30th.
30th. Huh?
On 30th July. Next week.
30th.
Yes.
So fix this matter on 30th.
Notice may be issued to opposite party 5 minutes is the.
Let them get instruction fast on this.
No purpose will be served.
Otherwise, let me take note.
Because these are agreed to us.
In the meantime,
In the meantime,
that
notice.
will be affected upon the opposite party.
Yes, let that be complete.
Do one thing. This is the matter on such and such.
Item 15.
Yeah.
Again, changing of the party number 6.
In fact, here the sanctioned location is place A. He is opening the shop at place D. Kindly see page 19.
19.
Yes, ma'am. As per the sale notice, he will have to say open the shop at the sanctioned location. Now kindly see page 19, page number 17.
17.
17.
Yes.
Golila Street, Berhampur, and sanctioned location is at Golila Street, Berhampur, Ward number 19, MC, Town, District, Ganja. Now there is also a shop at Kholasi side, which I am the successful attorney.
No. Name of the reference shop is the Golila.
Golila Street. He has kindly see note page
He's
18.
opening at Golila Street.
No, he is opening at Kholasi side. The at serial number 9. Next pardon.
Where do I get it?
How do I get it? Kindly see, he is opening the shop.
Yeah.
I am showing it to you. His documents through which he has opened it. But he has page 50 mallards may kindly see.
50.
Yes. This is his document he has filed for the purpose of taking license. Page 50. The sale deed. He is giving the plot number 769. Fourth line from the top, Kholasi Street, Berhampur. Look at page 50.
Base 50.
I am looking, this is a page 50.
At the top, handwritten person, not symmetry. This is the document over in support of the shop room.
Not Khalasi Street.
Kholasi Street, plot number 769.
Northern row of Khalasi.
Right, sir. Not Golila Street.
Okay, license.
Mr. Soy.
I will take instruction obviously, but to check it is Kholasi Street. Kholasi Street and Kholasi Sahil. Your Sahil means it's a big area. And the street fence is only one lane. That instruction has to take within that area.
Page 19,
Yes.
you have shown as at Golila Street. At
That was after instruction.
If it is within the vicinity,
or in the vicinity of the Golila Street, I can understand.
Yeah.
At means what?
Specified location.
Yes. But in the, it is written as Khalasi Sahib.
Where?
Policy side is different.
Where do you get it?
So, Odia version page 16.
Policy side is different, sir. Policy side is different, sir.
No, even in page 19, it is Khalasi Sahib.
Yes, that is a different shop. Policy side is some.
It says 17.
Yes.
He is concerned with 17, not 19, sir. He is applying for 17. Serial number.
Khalasi Sai, I understand, it's a Khalasi.
He is talking about 17, not 19.
Instruction is for but in Korea it is written as Golila Sahib. Korea it is written Sahib in the
No, serial number 17 in
Yes,
Golila.
17 Golila Sahib. Sahib is written Sahib.
He is reading vernacular.
Vernacular in Odia, page 16.
That is page
Sahi
60.
means what?
Sahib means a street area.
It's a, no,
Area.
Sahi means a hamlet.
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 But here, why English is saying
Street.
street?
Street, here it is street.
They have
If
published.
there is a difference between a vernacular language document and the English document.
Let's certainly not Khalali Sai.
The English also
Different location.
Certainly not Khalali Sai, like Khalasi Sai. Certainly not Khalali Sai. Maybe Golila Street or Golila Sai. Certainly not Khalali Sai. Khalila. Khalasi. And look at your lordship will see his license. License plot number given is of Khalasi Sai. That's the issue. License देखो ना.
What?
Personally, because there is some confusion.
Even in your mind or a confusion?
Yes.
In reality.
That has to take up.
Next week.
Item number 16.
Item 16, inspector to get instruction. I am challenging the demand notice here. For a period of 8 months, I functioned. But for a period of whole year, they have demanded the period of 4 months. For 8 months, I have functioned, but 12 months they have sought for, they have demanded. Challenging which I have come before your lordship, and your lordship had directed to get instructions. And my prayer is for renewal also. In the meanwhile, they have allotted to someone else, but through lottery. I filed IA, but it could not be listed on the last occasion, your lordship. They have given it to someone else.
What more?
Your lordship, legitimate expectations is there, your lordship. And as
To what extent?
so I have made a prayer, and during the pendency, they have allotted, your lordship.
We are simply concentrating on the demand.
As my prayer is for renewal also, your lordship. If your lordship sees my prayer, And in the instruction,
The
your
court
lordship,
will renew the license. You expect the court to renew the
Your
license.
lordship, if my prayer is for appropriate money has to be demanded, I would have paid and have got my license renewed. Because of exorbitant
Yes.
demand.
What is the demand? Demand?
Yes, your lordship. Your demand, page 25.
$84 lakhs.
No, page 25 is for 1 crore 56 lakhs 26,000. And next page,
84 lakhs.
page 25, annex 6 series here also. WPC 9961 here also.
84 lakhs. That's the last election.
Yes, your lordship.
So 84 lakhs. 84. I think you are carrying a wrong brief.
No, there are two matters connected, your lordship. Same case, your lordship. I'll just. Yes, your lordship. 84 lakhs. And this is 83 lakhs. Page 24, 25. In the other case is 1 crore 56 lakhs and 1 crore 60 lakhs. For the whole year, your lordship. Whereas I have
unutilization.
Mohula power unutilized.
What do you do with this? Manufacturer?
I'm a manufacturer. It's out still.
OS.
Sir.
So why you have not utilized this?
No. Here it was for the whole year they have calculated, your lordship. I have a license. No, I have approached before this honorable court, your lordship. This honorable court directed to from in the month of July last year to grant a license for renewal as well as for payment, your lordship. It was granted to me in September, your lordship. I paid everything and it was granted to me. License was granted to me in September. And from September, I have been paying, your lordship. In the month of February, they have asked me to pay from April, your lordship.
So what is the utilization for the whole year of license? It was operating from a retrospective date or operating
only from the license.
I'm asking you, when the license was renewed to you or given to you?
Yes, sir.
In the license, have they reflected?
Yes, page 15 of your lordship sees. Page 15 of your lordship sees. Page 14 and 15.
Oh, yes.
Date of validity of transport pass, that is 31/8/2025. And 31/15.
No, I am talking about the license.
Yes, your lordship.
Where is the license?
License is at annexure 1, page 12, your lordship. This was granted. Roman is valid till 31/3/2026.
I understand.
Yes, and it was executed on 7/8/2025. The next page, it is sign is there at the bottom.
Understand.
In fact, I have not received the instructions. I may come next week, but I will take instructions.
You asked for the sign last week.
You
asked for it.
Here at one hand, they are not supplying instructions. On the other hand, lottery has been conducted and third party has been engaged. I filed 2 IAs, your lordship.
All shops are put to lottery mode, and in fact,
during the pregnancy, if this honorable court asks for instructions, your lordship, without supplying instructions, that this is the amount and justifying the demand, or
So far as the demand is concerned, I will obtain instruction. Next is
my prayer is wholesome, your lordship. It is one for demand. If actual demand would have been that, I would have paid, your lordship. And my second is for renewal. That is pending since by April, your lordship. And I have filed 2 IAs not to give third party interest.
No, sir. You cannot take that note. And when they have done it, after the matter was first taken up.
Yes, they have done it last month. This month they have done it. I filed 2 IAs to that effect.
Well, it was taken up on 16/4 and it was on your prayer. Why it was not listed on 23rd of April? Why it was not listed on 23rd of April?
Somehow it got listed as well.
Why you did not mention immediately?
I mentioned, your lordship, I mentioned it the next, on after 23rd also I mentioned, your lordship, and I filed 2 IAs to that effect. They have done it in June 2025, June 2026, your lordship. Then
You were served.
yes. 2 IAs have.
This is not, this is not.
The license period expired on 31st of March, and thereafter
They have asked before there was an outstanding, we will not renew. We have challenged that there cannot be any outstanding against me. And that's why opposite prayer was made, that first is that the demand should be cancelled and the renewal of the license. So what was, why there was an haste when you asked for an adjournment? Okay. We are making an observation. We are making an observation and adverse inference has to be drawn in these matters. And who is the authority? Who is the authority?
The collector, your lordship, and superintendent.
No. Who has issued?
This was issued. If IA filed at flag 3, your lordship.
I'm asking who has issued the.
Collector has issued it. Collector has issued.
Collector on the recommendation or he is the person?
I had copy to all so and so. Squared of the on the recommendation of superintendent.
Superintendent recommendation was. What is the date?
It was the collector had issued on 25 June 2026. 25th June. No, that is, I am not.
The collector, whether the collector is a party.
Yes.
Yeah.
Yes. Collector, superintendent, all the parties.
The reason is because the license period expired, my lord. Therefore, my lord, this process was set in motion. That is the only. Because there was a direction that another person instruction.
It is one of the classic example where
Both the cases same. Both cases same.
We are passing this order in case
Yes, sir.
that matter, whatever it is.
Please stand.
Up to?
Pursuant to direction of this court, I have sought a copy of the
Yes, he quoted the lowest price. Why you are not giving it to him?
Notes. And on to page 13, Annex 1.
Yes. Show him.
Page 13, Annex 1, my lord.
Correct.
Clause 3.
Yes.
The vehicle must be in
Roadworthy, newly hiring.
from the date of physical registration
Correct.
and must have valid registration certificate, insurance certificate, fitness certificate, valid contract carriage permit, proof of up-to-date tax
Correct.
permit, etc., which are mandatory for flying of the vehicle.
Correct.
Mine.
Yes,
And
purchase the new vehicle.
Then kindly see clause 10. 10 manner. The
Honor before 15/4.
in all respects should reach the undersigned honor before
15/4
2000
by 2 p.m. No
at 2
difficulty.
p.m.
Yes.
Madam, my humble submission, he has no valid registration certificate. Insurance,
He
and
he has given it. He has given it by making a payment.
yes, my lord.
Registration number is given.
Yes, my lord. Kindly
So-
on to page 19, my lord.
Yes.
Registration certificate.
Yes.
In the middle, my lord, date of registration.
Yeah.
16 April 2026.
Where do I get it?
At page?
At page
19.
What is that? Yes, the card.
Valid date of registration, my lord.
16.
April 2026. Not by 15/4. Then, my lord, next page 20. The validity of the permit from 16th April 2026 to 15th April 2031, my lord. Then, my lord, next page 21. Validity of the permit, clause 8. Same, 16th April 2026
Yes.
to 15th April 2031.
Correct.
Then, my lord, insurance certificate, my lord. Kindly come to insurance certificate.
Yes.
Page 18, my lord. In the middle, clause 3, my lord, period of period cover 15th April 2026, 3:10 p.m. to 14th April 2026.
Where do I get it?
That's at the top.
For which his bid has been rejected, ma'am.
No, that is not an issue. That insurance will do because it was on 15th, 3:10 p.m. You say that it should be at 2 p.m.
3:10 p.m.
Where do I get it? 10 p.m. 3:10 p.m.
3:10. It was up to 2. He said that it was up to 2. By then it was.
Ma'am, for which this bid has been processed, bid of the petitioner has been rejected.
But you also may kindly see on 15th, there was the last date. I had submitted all the documents and I was allowed to participate. The documents matter I had shown to your lordship. Therefore, your lordship, whenever I was selected as L1 bidder, Annex 4 kindly you have a glance.
Annex
4, page 20.
Page 20.
Page 20. So I was directed to produce the vehicle for verification.
only in the intention, my lord, to take that vehicle, as I was not selected as L1 here. As per bid on the reference, you have submitted the tender document with engagement of your new Bolero vehicle for engagement official work at L1 subdivision Athagod on 15/4/2026. So you are herewith instructed to produce the vehicle. They have not stated anything else regarding that. For physical verification at the office of understand within 12 to 2 p.m. on 16/4/2026 without fail. Any deviation in this matter, madam. So I had given my that I though in on 16th I was not well. I produced that vehicle on 17th and it was verified on 17th with all documents. That at the time of verification of notice, I had submitted all these documents, say which is valid to be considered as L1. Because the registration was 13th. You will also kindly see page 70. It is a valid registration on page 70 by depositing extra money on 13th.
And the registration number was given.
Yes, registration number was given. Registration number OD05 CK0046.
What a registration they have? No, it's a permanent number that is given. OD05 CK.
It was considered. I was allowed to participate. If my documents were not correct, I would not have been allowed.
There is no condition that the documents have to be produced. See, it should be a roadworthy. CK, what does it mean? That's a permanent number.
Yes.
OD is given. And that is given on 13th.
13th.
But subsequently, registration certificate has been issued.
That may be a different one.
On 16th,
Maybe that is a recording in their register.
my lord,
Who is the other side?
I am for the Lip Irrigation Corporation.
Yes. And whom you have allotted?
L2,
L2. Cancel L2.
Lordships, kindly see.
We are dictating
This
the.
letter under annex.
Yes. Despite the petitioner being adjudged
He has not filed in the written application. There is a terms and condition, but he has not filed in the present written application. The documents which were produced by the bidder before the authority, I have the copy. Your lordships kindly see, there is the
Sir, why you issued a letter on 15/4/2026? Why you permitted the verification on 17/4/2026? If there was any discrepancy in the offer submitted by him, you would have rejected it being not in conformity with the terms and conditions of the quotations. That you do not do. You cannot improve your case for the first time because MS Gill judgment of the Supreme Court is staring at you. We have simply said that since you have communicated to him and this terms and conditions does not envisage that the documents have to be produced on that. It is at the time of plying of the vehicles when you wanted they should have all the certificates. That's all. That's all.
Some annexure 4 when authority.
It may be 16, I don't mind. It may be 16, we don't.
He has not produced the vehicle.
Oh, that is, he says on the second day there is.
On that, he has not valid registration certificate.
That is as on 15. I have discarded it, that terms and condition does not envisage that.
Item 17.
17 man at
2 weeks.
Item number 18.
They are coming under exemption law, 12 meters.
Yes, sir. I could offer an instruction with regard to that 14 meters.
Well,
Keep it to Monday or anything.
Sir, how many times you require, and if your authorities are lackadaisical, if they do not care to give you an instruction, I think they should face the music thereof. The court cannot mechanically go on adjourning the matter day after day as the authorities are not giving instruction to you. No, every time, sir, because of your persuasive appearance, the court is granting an adjournment. That does not mean that they will treat the court for a ride. There should be an end of the litigation. These are the small litigations. Except on that, for that on the last occasion you asked for a time, we granted you a time to take instruction. Now it is more than 20 days, and they have not given you an instruction. How long the court should wait? What do you think? And unnecessarily these litigations are pending, exploding the docket of the court for no reason. The court cannot be put to fault. It is because of this, I think, lethargic or a dormant attitude of the authorities, the matters are being dragged. Who will bear the cost which the litigant, the petitioner, is bearing for engaging him? Who will bear? There should be some alacrity shown by the government officials.
One more chance, I don't know, only one more chance.
So 2nd of July was, you asked for an instruction.
On that you also direct.
And we permitted you to take. Now today we are on 23rd. 21 days, 20 days have passed. And a small thing. Just a verification whether it crosses the 12 meters or does not cross the 12 meters. That's the only instruction was needed. Law is very well settled. If it is below 12 meters, no permission. If it is above 12 meters, then it requires permission. And you will not able to say us that whether it is beyond 12 meters or below 12 meters. So this is something I cannot expect. There should be an introspection from your end. We don't approve the theory of calling them into the court and then but there should be some respect to the court. If they do not come, we will go by his version, that as if you have nothing to dispute. Call the next.
Item 19.
May I please, Malak? In this matter, Malak, I am an intervener, Malak, and I am the necessary party, Malak. So the petitioner has offered Malak is snatch out an order from this honorable court, Malak. Yes, Malak. Because Malak, why you are laughing, Malak? There is another petition, Malak.
When you are using this word,
Yes, Malak. Another read is
know when you use any words.
Yes, Malak. I'm sure because another read is pending, Malak.
Snatch out means what do you mean by that?
By
What is the
suppressing
meaning of that?
by suppressing the truth, Malak.
That is then again say by suppressing the fact they have obtained the order.
I'm sorry.
Snatch out the order.
Yes, Malak. I'm sorry for the word, Malak.
No, you are very agitated. No, I have all respect for a concern you are showing for your
Yes, Malak.
client.
Yes, Malak. Because I am the owner,
You are
Malak.
a responsible officer of the court. You should be very careful when you use any word.
I beg apology, Malak. But I am as old lady.
Maybe you have a grievance that you will place your grievance.
Malak, another petition is pending, Malak. That is WPC number.
Whatever the suppression rules, we go through it. Yes, you are an intervener.
Yes, but I am
Have
the-
you filed an application?
Yes, but I have filed one.
Where is your application? You have the experience.
Copy may be served on me.
Subject matter of dispute in the incident.
Now, here let's say simply inaction for renewal of the license, let's see. Here not.
This is one issue. Where you have what is the so-called notice?
Let's kindly see, let's see, sir, last order. It is all reflected everything, let's see. 2726, 2726, let's see, order.
Where is our?
Let's see, in this is the application. 2726 is very clear in let's see. My lot of friends stands also there, let's see.
talking about one writ petition.
Yes. Two read applications, let's say given that, let's say given, reflected read application.
Where is that?
Let's say can you come to page 2? Page 2 of the brief, let's see. The certificate, let's see, all the read application reflected that these are the read applications pending, let's see. And it starts from para 9, let's see, 10. And the detailed sequence of events also reflect in the read application. Yeah.
I do have that copy of the reproduction matter and go to the prayer. The same prayer is in this reproduction matter. Same and
I will come to you.
Yes, ma'am.
And will put you
Ma'am.
lot of questions to
Ma'am.
answer. Let me first clear my own conscience that what is there.
Ma'am.
Emotional, sympathetic pleadings have to be considered in the different perspective. Yes, so these are the two writ petitions, 960 and 2469, which he has disclosed in the petition. One he has disclosed. This relates to what?
This relates to they had seized the entire lordship, the establishment, hotel and lordship of shop.
Off shop or on shop?
That's it. This is on shop, sorry, on shop lordship. Both were seized lordship.
See, the 960 pertains to what?
960 lordship pursuant to lordship's direction, commissioner passed one order for demarcation.
No. This is what relief you have, what you challenge.
Lordship 960 lordship. Lordship, the order of the commissioner is under challenge. Lordship, can you come to the prayer, Lordship?
No, 960.
960 lordship.
What is not, you know, this is not annexed.
Lordship, I have a copy, Lordship.
No, what is the prayer? You,
May I read, Lordship?
wait. You have not been implemented as a party. You have no right of audience as on this time. Yes.
May I
What is the prayer?
Prayer, under the facts and circumstances as narrated above, the Honorable Court may please to quash the order dated 11/12/2023, Lordship, under Annex 14 and 19/12/2023 under Annex 16, passed by the opposite party.
What are those orders?
Those are passed by the commissioner, Lordship.
What is the nature of those orders, sir? I just wanted to know what is the nature of those orders.
Lordship, the entire establishment are sealed by the.
So that is why, by virtue of these orders, the entire hotel
And-
as well as the on-shop license, IMFL on-shop
That's
license, they are sealed.
Lordship,
So you challenge those orders
Lordship.
in 960.
960.
This is pending.
Pending. In the meantime, Lordship,
Now, what happened? Why 2469?
Lordship 246 in the Lordship mid-session, Lordship, commissioner passed another order for demarcation of the land, Lordship.
Okay.
For demarcation of the land. That is under challenge. Now, Lordship, they have
So the commissioner passed an order for demarcation of the land.
land
Okay. So that is also under challenge.
under challenge. Now, in the meantime, Lordship, they have Lordship withdraw the Lordship, the seal, Lordship. They open the hotel, Lordship.
So 960 becomes infra.
Lordship, not in view of the infrastructure.
Subsequently, if they have lifted,
Lifted,
that
Lordship.
means 960 becomes infra.
Infrastructure, Lordship.
Then
Now the last,
69,
now the renewal part only comes to play. Now we are
69 demarcation,
demarcation, Lordship. That is under challenge, Lordship.
that is there is pending.
Here, Lordship, pending, Lordship.
That is pending.
Pending.
Demarcation.
Pending.
Okay. Now here, you wanted a renewal of.
Renewal of the license.
They have not acceded to it.
No, Lordship.
They have not acceded.
No.
Let me first understand.
License.
Yes, did you withdraw that CD?
The seal and withdraw, my lord, if my lord will see on the last
Pen
occasion,
means straight away.
my lord, on the last occasion, my lord had passed an order for the petitioner's representation to the disclosure. Order on 2/7/2026, my lord. So, my lord, my lord, I have given that order, my lord. We have passed an order, my lord. There is an interim order operating in 960/2024. regarding the demarcation. So, my lord, the authority.
No, it is 960 is not a demarcation.
My lord, it is, there's a, it is a model.
Demarcation is 2469.
No, 960.
You said me, you wrongly told me. You wrongly told me. That's why I wanted to have a clarity of the facts.
Extremely sorry.
And in that 960 have given the order, my lord, there's an interim order operating regarding demarcation.
So demarcation has nothing to do
Yes,
now.
my lord. Now, my lord, I've given the instruction. My lord will see a demarcation is required, my lord, because as it appears that shop, the on shop is not operating on the place allotted. That the petitioner claims that he sent it by way of a gift deed, that particular plot. As it appears now that on shop is not operating on that particular shop. So demarcation is
The shop means what?
the on shop is not operating on that plot which was gifted to the petitioner. So now
he's
the
operating on
demarcation
Which plot?
on my plot. Yes.
Which plot?
My lords, I've given an instruction. My lords will kindly have. I've highlighted the relevant paragraph in the second page. My lords.
Let me first ascertain, then I.
Yes, my lord. My lords will see in the second page, second paragraph onwards.
Yes.
So they mention the plot numbers, my lords. They do not tally.
Sir, what is the plot number?
My lord, they say, my lord,
where they are operating, and what is the plot number which comes under the deed of gift? What is that? Tell me the distinction. Yes, you have said in the next line, the relevant license is obtained and has been in operation since 2003. The legal license clarifies that is running over the plot number 816 by 1330.
Yes, ma'am.
And not over another plot. Though on shop is operating only over the plot number 860 of 1330, and which is recorded in the name of the petitioner. Harshit. I was just trying to understand from my brother who has the knowledge so far as the local is concerned, but I had a broader aspect of the another. Very interesting. What is the concept of a butter plot? Butter plot. Butter plot comes when there is a large plot and a portion thereof is carved out therefrom. Then it is always regarded as a butter plot because originality is there, that it is a part of the original plot and then it is carved out by such portion to another. It remains a portion of the whole of the plot and it's been segregated. If the report says that the hotel is situated in the whole of the plot, not in a butter plot, can a butter plot be segregated from the large plot? Either it is partly on a butter plot, partly on the rest of the plot by encroachment, I can understand. But your report says that it is situated on the whole plot, which includes a butter plot. Very interesting. And that is why the reason I think the court has stayed the demarcation.
My submission is if now a new demarcation is made, Millard, that may put a quietus to the issue, Millard, because at least Millard factually will be clear, Millard.
On what basis? I just wanted to know what is your authority? I will come to him later on. What is your authority? You are a license issuing authority.
Yes, Millard.
That's all.
Yes, Millard.
You have issued a license in respect of a particular plot or a building. If it appears that he has submitted the document, in absence of any corroborative evidence, can you go for a demarcation within your competence? The
Excess
can do it.
No, actually not, Millard.
Then it is a land department who can do it,
Yes.
which is a custodian of the land records. Who are you to do it?
Millard, there is a cross demand, Millard, by the other side also.
Can you decide that I
No, I cannot. We cannot. The
So,
excise authorities cannot.
Sir, then what are you doing?
Authorities will do. That Millard, the excise authorities cannot. So that's why Millard, they have requested the Tahsildar, Millard. That is why it was inquired into by the Tahsildar. They have made a requisition.
Can you? On what basis? Somebody has come and claimed the rival title, and you will decide. You have to act within your authority.
The excise authorities cannot, Millard. That is a fact, Millard. But Millard, because of this, Millard.
Because of this, how can you? I am just asking.
Millard, may I call for the record of the other expedition, Millard, to let both cases be taken together.
This is what I understood. One is the relation to a CV.
Yes, Millard.
Now, according to him, since you have lifted the CV, so that has gone.
Yes, Millard.
And they may not. But so far as the demarcation is concerned, they are still pursuing their remedies, and which is pending.
Yes.
Correct?
Yes, Millard.
Now, sir, I put my.
Well,
Give me, satisfy me the test of necessary party and a proper party in relation to a subject matter of dispute.
kindly have a glance that.
First thing is, one has to find out the main the ingredients of a necessary party and a proper.
Kindly have a glance that RI report,
Who is a necessary party? I am asking.
In the previous repetition, I
am asking you who is a necessary party.
I am the affected party, because I am
again saying you.
I am the owner of the property, I am the owner of the
I am again saying
this
who is a necessary party.
Who is affected,
No.
I am affected.
Then you are under misconception.
No, RI report is there, I have
I am again saying, if you do again, I am saying you cannot espouse your own cause by intervention. I'm again saying who is a necessary party and a proper party.
In the writ petition 960, I am a party, they have been implemented, but in this
We are
petition,
not
they have not
concerned
been
with that 960. Demarcation, definitely when anybody's property is being demarcated, then he's a necessary party there.
Yes, well, my property is demarcated, I have given the report.
I am not on that demarcation. Please tell me in this repetition how you are a necessary and proper.
Because
party.
my lord, that bar and that illegal bar and that restaurant on my property, on my land.
No, you are not able to get lordship. What is the ingredients of a necessary party lordship?
My lord,
Become a necessary.
my lord, when a person is affected, my lord,
No,
and
no.
because
No,
this is-
I think you have not read the judgments where the apex court has said that who is a necessary party, what ingredients are required, and why a proper party, what ingredients are required.
So for this matter is concerned, my lord, if my lordship allow, then I'll say the background of this matter, man.
Please, sir, we appreciate emotions, sympathy. Supreme Court invariably has said the emotion and sympathy cannot override the law. If the law appears to be harsh, it has to be accepted in that way. If the law is to bend on emotions and the sentiments, I think then there's no necessity of promulgation of a law. I am asking you, sir, very simple, that when a person can come within the ambit of a necessary party and a proper party.
My lord, because there was a numbers of petitions, my lord.
That means
And
a person who wanted to espouse his independent cause becomes a necessary party. I'm asking.
Yes, in this matter, my lord, I am a necessary party. Because it's my
That
property.
word is, tell me then how. Test to satisfy a necessary.
Because-
What is the test to satisfy a
My lord, let me satisfy my lord, because this land belongs to me, my
Going
lord.
to facts, sir, again.
And that is the
I'm
RI report,
asking
my
a
lord.
proposition of law, abstract, test to justify, to satisfy necessary.
The person who is affected, my lord, and I am here affected, my lord, it's my land, on my land, they have running a illegal beer bar, my lord.
No. No. That shows, then I was avoiding certain observations. If you say these words, it has a cascading effect. If we record this, we do not know what we know.
And so for my lord, this latest writ petition is concerned, my lord, it is also it is res judicata, my lord.
You have to understand.
In 960, he has
No,
taken a
sir,
stay, my lord.
there was a seeding, there was a 960 is a demarcation.
Not only
It is
this,
what is the res judicata? Like tell me, then again I'm going into a nuances of law. What is meant by res judicata?
well, when a matter is open, my lord, and when there is a relief is there, my lord.
No. When the matter is open, never.
960 is open, my lord, that matter is pending, my lord. That matter is pending, and he has taken a stay.
Is a res judicata.
He has taken a stay on the demarcation, my lord.
Is a res judicata. Then section 11 has to be read.
Then well, he is asking the same thing in the present writ petition, my lord.
What res judicata or something else? Res judicata will apply that in a previous proceeding, if the issue involved in a subsequent proceeding was directly and substantially an issue in the earlier proceeding and have been decided finally by the court, then the court will not decide the same issue in a later proceeding. You are saying the earlier proceeding is pending. Where is a final decision deciding the issue to attract section 11 of the Code of Procedure? Read the language of section 11. It's pending proceedings. No final adjudication has been made. then what? There are provisions, not, but section 11 definitely not. Res judicata. Sir, there are two aspects. I'll take you very short. We respect your emotions. We respect your agony and anguish which you are showing. But I think every right is to be asserted in a proper manner.
Mal, I very kindly have gone through this RI report, Mal, where RI has clearly has mentioned, Mal, that he is having an illegal.
Sir, I understand. Suppose if he is having, one thing comes from your submission, he is in exclusive possession.
Yes, ma'am.
Once a person is found in exclusive possession of a property, and the possession appears to be a settled possession, because I find from 2003 onwards he is in possession. And you throw him out without due process of law. I'm reminded of AIR 1968 Supreme Court page 620. It says that nobody can be thrown out of position, even if his position is not backed by any title, without due process. Even if there is no title to support it, without due process. How can you throw him off?
Because there was a direction from the Honorable Court on 27th July 2021, Mal.
You are claiming a rival title in respect of a property. You please go and assert your right. Remember section 34 of the Specific Relief Act, what it says. If somebody denies or invades your right, you can approach the proper forum.
And the property which he is saying, Mal, that is a gifted.
Again I'm saying, I have gone through your petition. You are raising a question on the genuinity of the deed of gift.
Yes.
Executed by your husband.
Yes. Because.
And these authorities, the excise department, the collector will decide the title and will declare the deed to be a fraudulent one, ingenuine.
But rightly or wrongly,
I would be happy if such a day comes in the system, that the authority will declare the title, declare the deed to be voidable. I will be happy. What the court system, how the court system will work like you.
And that bar was rolling in a forcefully manner.
Sir, don't you know? And you know, it is within your knowledge that the document, the deed is void. When it came to your knowledge, you have been asserting since long. Are you aware of certain provisions? What you are doing?
Even an affair has been lodged, Malad, against.
That is the proper way of getting away with the decree. Criminal court will declare a document to be void.
No, man. So, affair has been registered, Malad. Then I have taken the shelter, Malad, after a long Malad process, and that has been stopped, Malad. That illegal Malad. And RI has given a clear cut report, Malad. Where can I read out, Malad, that portion, Malad?
No, nothing. You wanted to settle your own. Yes. This is an application at the behest of the the report.
Well, this is a report.
This is, so there is another report which we have highlighted to him. That what he has relied upon that particular instruction.
I have given the right report.
Sorry, he has relied upon that instruction. We have gone through it, put up questions.
This is the RI report, Malad, who is the RI clearly has mentioned Malad.
When writ petition,
After 1 week, after 1.
now you understand.
Yes, ma'am. After 1 week.
Well, this matter may be tagged Malad 980.
It is a different subject matter.
Your matter is found. You could not get the order probably. You could not post. The order was vacated. You could not post it. Whether you are a necessary or proper party is to be decided.
Because I am the proprietor, I am the owner of that property, Malad. And that part which is gifted to him, Malad, there he has not constructed. He has constructed on my plot.
Sir, again I am saying, don't you realize that what is the proper forum?
That civil suit must be there, Malad, but
Is your wisdom, sir. We cannot make any comment. Yes.
Item 21.
Instance, Malad.
Yes, thanks.
21.
I have requested my other side matter. It will be taken up next week. But because there was a direction by this honorable
You are
court.
denying it, Krishna. Look at his name. And you are denying it.
Achha. But since my management is requesting for an adjournment, but I just remind you,
There was a
adjourn some other date, but your lordship may.
Last occasion, Mr. Tripathi was there.
Scope of
There was a
adjudication.
direction to produce certain records. So
But it may-
he's not,
Mr. Das
it
is
is
saying.
because of
this
his
is-
personal difficulty, so that is why I requested my.
I do not,
List.
we do not object to it, but very limited scope of adjudication remains now.
Item 22.
Next week.
Yes, next week. Next week. 30th. Item 22.
Why? They do not want any liquor shop in their area. What are they doing?
We would be like seeking time to file a rejoinder.
I am looking at your matter 22.
Yes, yes.
I have seen your prayer. Have you seen? Not to allow any kind of a liquor shop in favor of this, near to this.
100.
Not what.
Yes, so there
Want to steal the march. Told person to sell and cater the need of the locality, not to share.
That reminds me of a judgment of Kerala High Court of the Supreme Court, State of Kerala versus Kanda Distilleries. This is an exclusive privilege. Res extra commercial. It is only the state who decides where it has to be.
This is, brother. Who is appearing?
Advocate Purpose of Panijan.
Where is he?
He's a court of the Alabama matter.
What's your good name?
Debawala 19
You are not connected with the matter.
I have joined him recently too.
No.
In fact, his senior requested him.
You are not acquainted with.
2 weeks.
Yes, sir.
Item 23.
License fee and application fee under Orissa Excise Act. Whether may not be entitled to take license fee or application fee. No matter. Pick up the second case. Second case. My lord, on the last occasion, my lord directed.
Second committee kind. 43, quiz as short. Yes.
Yes. My lord, in that case, my lord had passed an order on 26/8/2025.
Yeah.
Yes. Just may I place it, my lord. From there, my lord, the entire issues will be clear. Admittedly, the petitioner is a manufacturer of Godaku, where the molasses are used as a basic raw material. The petitioner was issued with a half margin memo dated 28 May 2025 by auditor of excise.
No, I think Godaku is completely banned here in the state. Okay. You banned some chewing tobacco and all.
My lord, there is a case going on, my lord, similar case regarding tobacco is there, it is not banned. There is a.
Just besides the building.
But that is available.
Akbar Khan Guda.
Very famous Akbar Khan would have been good. This is that.
There was a notification, my lord, in regard to CORAM code. It was state region. Good. And the petitioner was issued with a half margin memo dated 28 May 2025 by auditor of excise department Kolandi, and consequently a so-called notice was also issued with category allegation that the petitioner is running a manufacturing activities without a valid excise license during the period from 2017-18 to 2022-23, and a demand was initially raised for a sum of rupees 5,45,000. Though the petitioner took a defense in the reply that he has discharged all his obligations as required under the law, and in fact he has paid the excess amount, but subsequently the demand was increased to 76,95,000. The instant writ petition came to be filed challenging the said demand with a substantive prayer that section 2 within the brackets 12A of the Bihar Orissa Excise Amendment Act may be declared as ultra-vires, having offended the provisions of the Constitution. The petitioners further prayed for exemption to use of molasses as a raw material for manufacture of the said Godaku industry by using molasses as provided under section 94 of the said Act. The learned counsel, appearing on behalf of the petitioner on instruction, submitted that his client is not placing the aforesaid two prayers made in the instant writ petition and is restricting the determination to the demand notice, which is also impugned in the instant writ petition. In view of such submission, the prayer number 2 and 3 are hereby deleted, being abandoned by the petitioner. So far, the demand raised by the authorities is concerned in the counter affidavit filed by the state. It appears that same has been reduced to 11,40,000. The petitioner seeks for an interim order so that the recovery process as regards the demand so raised may be put a halt until the final disposal of the instant writ petition. The facts are distant from the record revealed that the authorities have varied the quantum of levy with which the petitioner is statutorily bound to pay and have substantially reduced the same from rupees 76,95,000 to rupees 11,40,000, which is reflected here on. While passing the interim order, this court may strike a balance between the rights of parties until the final adjudication is made. it would not be desirable to pass a blanket interim order staying the demand raised by the authorities as it tantamount to granting of a substantial relief claimed in the instant writ petition pending adjudication. The court must bring the equilibrium between the rights of the parties pending final adjudication, and there is no fetter on the part of the court in putting the parties to the terms at the time of passing an interim order. Since the quantified amount as demanded by the authorities appears to have been varied at interval, we feel the pending adjudication of the dispute involved in the instant writ petition, the petitioner is entitled to an interim protection but on terms. We therefore direct to deposit a sum of 11,40,000 with the registered Judicial High Court of Orissa on or before 2nd September 2025 without prejudice to the rights and contention raised in the instant writ petition. On deposit of the said demand within the time stipulated, the authorities shall not take any coercive steps for realizing thereof until further on such deposit, registered judicial shall invest the same in the interval. Since the vital question is raised on the applicability of several provisions and the demand being in violation, therefore, we feel it that the authorities should not proceed for the recovery of the demand until the disposal of the instant writ petition. In the default of appropriate deposit within time indicated, the interim order granted shall stand vacated, and ultimately it will be open to the authorities to proceed in accordance with law, irrespective of the fact that the writ petition is pending before this court. My lord, after this order, I have deposited this amount. Now there are two legal issues. First legal issue is that whether the petitioner is entitled to pay the application fee and the license fee. Second, my lord, at various intervals, my lord, they have changed their demand, and latest demand was 11 lakhs, and out of that 11 lakhs, my lord, 5 lakhs was a penalty amount. Now, while demanding so, my lord, they have never issued me so cause notice. Now, my lord, let me first go to the first legal issue, that is the payment of application fee and the license fee. Under, my lord, Orissa Mere Excise Act, we have Excise Act. Sorry, my lord, Orissa Excise Act 2008 and Orissa Excise Rules 2007.
They are imposing under the Bihar.
No, Odisha.
No, but you have
mentioned, I had mentioned regarding the ultra vast. That is gone. That is gone. That is gone. My lord, may see section 28. Yes. Chapter 5, duty and tax. Nature and component of excise revenue. Excise duty and fees shall be levied, recovered under the following heads, namely excise duty, countervailing duty, license fee, VAT and brand registration fee, import duty, export duty, and other fees as may be prescribed. My lord, here my lord may see that clause C is about license fee. It talks about only license fee, my lord. Thereafter, my lord, section 90.
Why not H?
My lord, sorry.
H.
Other fees as may be prescribed, my lord. That I will explain, my lord, because here they have
reminded. Then apart from license fee, other fees that
is application.
That is
yes.
Then
my lord, may see page 90. 90. Power to make rules. One.
Section 90.
Yes. Section 90. Power to make rules.
Yes.
My lord, the state government may make rules to carry out the object of this act. 2. In particular and without prejudice to the generality of the foregoing provisions, the state government may make rule for X, regulating the time, place, manner of payment of duty on intoxicants and fees under different provisions of this act. So they have a right to make rule regarding payment of fees. So my lord, only my lord, we have seen that there is a license fee, there is no application fee has not been prescribed under section 28. Now my lord, I'll straight away go to the rules. My lord, it starts with rule 234, man. Collection, possession, storage, and sale of molasses. Here we are only concerned with, my lord, storage of molasses, which will be used for a bona fide use, that is for manufacturing of vodka. And straight away I'll come to 236 and 237. These are the most essential rules, my lord.
Yes.
Application for storage and possession of molasses. Any person or institution. Rule 236.
236. Yes.
230, application for storage and possession of molasses. Any person or institution, including a sugar factory producing molasses, or a cooperative society or a government establishment desiring to store or possess molasses for a period not exceeding 1 year and quantity not exceeding the limit for which security has been deposited, at least at the rate specified by the state government, for such storage for the purpose of sale, import, and export, shall make an application to the licensing authority in form ML1, and in the case of possession for the bona fide use, shall make an application in form 2 for grant of license, my lord. There are two applications, my lord. That is, application is ML1 and ML2. Then, my lord, 237, very important. 1. On receipt of an application in form ML1, the licensing authority shall, after due inquiry by an officer not below the rank of an inspector of excise, and on payment of fees as specified, may be determined by the state government from time to time, and on satisfaction of that grant of license is not detrimental to enforce or prohibition in the area of storage or possession as applied for, grant license in form ML3. And in event of refusal to grant license, the licensing authority shall state the reasons thereof. My lord, kindly see what is this ML3, ML1 and ML3 in the form, that application. In the form, my lord, it has been given. That is, my lord, form 1 is for application for license for possession, storing, import, export, and sale of molasses. This is the application which will be given under ML1. Then under ML3, my lord, the license is given for possession, storage for sale, export of molasses. My lord, we are not coming under these two things. My lord, second provision on 2, my lord, I'll place 2, sub-rule 2, my lord, of 237. On receipt of an application in form 2, the licensing authority, after due inquiry by an officer not below the rank of inspector of excise, and on satisfaction that the applicant follows the Indian Standard Institute formula or formula approved by the Industry Department or Fishery and Animal Resources Development Department in case of cattle feed. My lord, we are not concerned with that. Only D. D is very important. The adequate storage facility exists for storage of molasses may grant a license in form ML4 on receipt of storage fee as determined by the state government from time to time. My lord, what is the main departure from both this? What comes out from both this provision 1 and 2? 1, when it is for possession, storage, export and other things of molasses, my lord, the state government, the authority on payment of a fees, my lord. It clearly states in sub-rule 1, it says on payment of fees. But two, my lord, it is in regard to our case, when we are only storing it for a bona fide use and we are making an application under ML2, there is no such thing that payment of fees. It only says on receipt of a storage fee, my lord.
Yes.
Now, my lord, kindly see.
Yes.
It never speaks of any application or on payment of fees, my lord. It never says so. Now, my lord, the form ML2, my lord, may get it at the forms, my lord. It says application for license of possession of molasses for bona fide use. This is the application, and license we have got under ML4, my lord.
Yes.
My lord, my submission is this, that when the rules are not providing for any payment of fees, then under what account, my lord, the authorities are demanding the license fee and the application fee? First, my legal submission. My lord, they have the authority to frame rules and they have rightly framed the rules on payment of fees, my lord, when it is for other purposes like storing of molasses for export and other things, my lord. Then there is then they have to pay on payment of fees, my lord. The application fee has to be paid and license fee has to be paid. But when it comes to only for possession of molasses for bona fide use, there in sub-rule 2, there is no payment of fees, my lord. It only with regard to a storage fee, my lord. That is D. To D, my lord, it says that on receipt of a storage fee as determined by the state government from time to time. Now they are claiming, my lord, license fee and application fee is applicable to me because I am taking this license under ML4. Now, my lord, second limb of submission is this, that the demand that they have made, that is, my lord, may see the repetition. Para 15 of their counter affidavit, my lord. Page 6 of their counter affidavit. What? My lord. Counter affidavit by them, my lord. Yes.
Counter affidavit line. It's in page.
Page 6, my lord. Para 15.
Yes.
In this contest, it is humbly submitted that petitioner was never directed to pay excise duty in respect of his industry, which is running for gutka business, manufacturing of gutka by utilizing molasses. The petitioner was only demanded the application fee and license fee in respect of its industry for gutka business by utilizing molasses. Gudaku business, manufacturing of gudaku by utilizing molasses. The calculation of application fee and license fee in respect of possession and use of molasses by industry for the period of 2021, 22 to 25, 26 is reproduced here below. My lord may see that they have given the entire demand over here. It was reduced from 76 lakhs to, my lord, 6 lakhs 40 is their total demand. And maximum fine as per section 62(2) of the Act is 5 lakhs. They have given this figure of 11 lakhs 40,000. My lord may see, and this demand has been made without any so cause, my lord. Kindly see, my lord, the first so cause that was given to. That is at writ petition page 42, Annexure 3 series. Annexure 3 series.
What?
Page 42, Annexure 3 series is the first SOCOS notice, my lord, they have given.
Yes.
SOCOS notice for operating without valid license. My lord, that is page 42. Page 42.
Yes.
Whereas it has been reported that you are engaged in trade and usage of molasses under GST registration without obtaining a valid license under Odisha Excise Rules 2017, half margin memo number 8 dated 28/5/2025 of Auditor Excise Department Odisha Bhubaneswar is enclosed for your reference. Whereas such operation is in direct violation of Rules 234 to 237 of the said rules. You are hereby directed to SOCOS within 7 days from the date of receipt of this notice as to why the penal and recovery action should not be initiated against you for the said violation. Then, my lord, the audit report at page 44. My lord, got it. Page 44.
That's the half margin.
Yes,
memo.
yes, ma'am. This is the audit report that they have.
Yes.
Right. As per the provisions of under section 234, 235 of Odisha Excise Rules, molasses shall be processed, used, stored,
Possessed.
sorry, sir. Possessed, sorry, ma'am. Shall be possessed, used, stored, or sold by any person or factory under a valid license or permit and subject to specified terms and conditions. It is used for distillation of spirit and for scientific, industrial, and medical and agriculture and cattle feed. Moreover, Rule 236 and 237 of Odisha Excise Rule says that the license in Form ML3 is issued for storage and possession, and in Form ML4 for above uses on deposit of prescribed fee as per AEP, that is annual excise policy. The molasses is permitted for store or possession or exceeding 1 year the quantity not exceeding the limit for which the security has been deposited at rate specified by the state government. Where the licensee desires to possess the additional quantity over and above the quantity for which the license has been granted, then he shall apply for said additional quantity and shall make a payment of such fee as may be determined by the state government. Accordingly, the audit was sought information on number of Gudaku and molasses units which were operating under the Kalandi district registration through half margin on 25/1/2025, and in response to that, you have endorsed our letter such and such. Thereafter, my lord.
Anyhow, they imposed 10,91,000.
Yes, my lord, they have imposed 10 lakhs for the period.
You have not applied for a license
My lord,
free.
My lord, what they have done, they have imposed that for 2017 and 18 to 22 to 23. This was the period.
Yes.
I gave my reply. In reply, I submitted that I have given all the challenge, application fee and license fee for all these years till 2021 and 22. All those challenges are there, my lord. At page 52, my lord may see. I have given. It's my lord, I have given. Then what happened, my lord? Again, they demanded 76 lakhs for my lord may see again at page 60. Whereas the half margin dated 7/5, my lord got it, page 60. Page 60. Whereas the half margin memo, last paragraph of page 60, my lord. Whereas
the department with confusing correspondences.
Again, my lord, they stated over here that whereas the unit has calculated an amount of rupees 76 lakhs only to be recovered from Sarma Industries towards application and license fee and penalty for unauthorized operation. Then office order was passed, my lord. Next page. and my entire premises was sealed, page 62.
It is still under seal.
No, my lord. After the interim order, it is running. My lord, again, thereafter, my lord, straight away, my lord, thereafter, they have not given me any notice, my lord. They only made a demand notice. Again, a demand notice was sent at page 67, my lord. Yes.
It's the second one.
Second one. And they rely upon the so-called notice of 5/6/2025. And they have raised the demand to 76 lakhs for that license fee and other things. Now, thereafter, my lord, thereafter, in the counter affidavit, my lord, they submitted that it has been reduced to 11 lakhs 40,000 and penalty of amount of 5 lakhs has been imposed. And my lord may see that section 62(2)
Empowers the fine up to 5 lakhs.
5 lakhs, but without any so, my lord, there was no so cause, nothing. That was absolute. The first so cause that was issued is with regard to 10 lakhs. Then again, my lord, 76 lakhs without any so cause. Then again, reduced to 11 lakhs, including that 5 lakhs as the penalty amount without any so cause. And my lord, I'm just reading out that section 62.
62(2).
Yes,
On
62.
the right hand side page, top.
Yes. Penalty for possession of intoxicant in respect of.
On the top, right hand side.
Yes, ma'am.
Subsection 2, sub 2 is quoted.
Yes, ma'am.
What it says, ranging
Any
from
owner-
such and such up to 5 lakhs.
Yes, ma'am. It may less than, it should not, it shall not be less than 10,000 or may extend to
Beyond
rupees
5 lakhs.
5 lakhs.
Yeah, minimum.
So they have imposed 5.
5 lakhs.
Minimum.
But that penalty amount, my lord, has not been imposed without any so cause. That has been imposed without any so cause. My lord, the authorities have gone in a different timeline that they say that different figures at different time. And first figure was 10 lakhs, they gave me a so cause. On basis of, and that was for a period 2017 and till 2000.
Understand that you wanted to say when the authorities themselves are not sure
Right.
that how much amount is due and payable by you. I think that even on such pre-verification, they cannot proceed on
Right.
that basis and the full opportunity has to be given.
Yes. And secondly, my lord, my submission with regard to that license fee and application fee, that payment of fees was never there for application under Form 2 and for getting a license under Form 4, ML4. That was there was no ingredient of payment of fees in that provision. This is my submission.
Yes.
Also, I've filed as affidavit to the regional affidavit giving all particulars for the sections and rules. I've put it there and annexed there. That's how it is relevant to the present case. In the present case, what happened? With the admitted case, he has not ever applied for
Given.
Rule 21(7). On 21(7),
Included.
That second case, I think.
in the
Second
1.28.
case, my lord. Second case is
1.28.
Same case. Same case, my lord, but there, my lord, I have challenged that I wanted to a transit permit, my lord. They say that because you have not taken the license and application fee, so transit permit cannot be granted. So it arises out of the same license and application, issue of license and application.
You entered transit pass from Gautani to the.
He is raising a question where is the provision for an application fees?
That is there itself. Also, planet.
And it does not, license fee also does not provide, is not provided in the,
Provided.
yes.
Also, I'm one by one, I'm pressing.
ML2,
Yes.
then there is no provision for a license fee. This is
License-
ML4.
Planet turn to section 2, that What is the intoxicant? 2T clearly provides the intoxicant means any liquor, other intoxicating substances other than narcotic drugs or psychotropic substances regulated by the Narcotic Drugs and Psychotropic Substances Act 61, which the state government may by notification declare to be an intoxicant and includes mahua flour and molasses. So arbitrarily molasses is an intoxicant. Then we receive Rule 14. Section 14. 1. The license required for depositing or keeping intoxicant in warehouse or other places of storage. So license required. Yes. License required for depositing or keeping intoxicant in warehouse or other places of storage. So for molasses, a license is required. The license fee he has to pay. No person shall accept under the authority and without a license containing the terms and conditions granted in that behalf by the collector, deposit or keep any intoxicant in any warehouse or other place of storage established, authorized, or continued under this Act, provided that such license for keeping of intoxicants by a wholesaler may be granted only with the approval of the state government. So no person is entitled to keep any intoxicant without any license. Then also can I turn to Rule 17, Section 17. Section 17 says, possession of intoxicant generally, no person not being licensed to manufacture, collect, or sell any intoxicant shall have in his possession any quantity or any intoxicant in excess of such quantity as the state government has, under Section 4, declared to be the limit of possession except under a permit granted by the collector in their behalf. Subsection 2(1) subsection 2(1) shall not apply to any foreign liquor, any study and other substances. Then we come to Section 45. Section 45. Section 45 prescribes for fees. Fees for terms and conditions and duration of licenses, permit and passes. Passes from transit pass. Now it's going for transit pass. Every license, permit or pass under this Act shall be granted on payment of such fees, if any, and subject to such restrictions and conditions as may be imposed and shall be in such form and contain such particulars as the state government may direct from time to time. Every license, permit, or pass under this Act shall be granted for such period as may be prescribed. So, for the purpose of license, he has to pay the license fee, permit for transportation. He has also to pay the transit pass. He has to pay for that. Then the relevant rules. That is Rule 236, right? Rule 234. From Rule 234 is important. Rule 234, Chapter 19. Collection, possession, storage, and sale of molasses. Then 234, possession, storage, sale, and use of molasses. No molasses shall be possessed, used, stored, or sold by any person or factory except under a valid license. So license is a must. Without license, and for license fee he has to pay. That is there. Mr. P. So any person, factory license or permit, and subject to the terms and conditions contained therein. Restriction on use of molasses. The licensee shall not use molasses except any of the following purposes, namely the distillation of spirit in a distillery established or licensed under the Act, any bona fide scientific, industrial, medical, agricultural, including use of capital field, educational or like purposes. Here includes this Budaku purpose. Application, then 236. How application is to be made?
No. How it comes, Gudaku?
Other purposes, like other purposes.
Like other?
Like purposes, or like purposes means?
Any other purpose.
Like means which is scientific, which is industrial, which is medicinal or agricultural. What is the medicinal value of the Gudaku?
No, that is not for that. That is there, but working. It is not working.
Then also finally come to 236. Application for storage and possession of molasses. Any person or institution, including a sugar factory producing molasses, or cooperative society, or a government establishment desiring to store or possess molasses for a period not exceeding 1 year and quantity not exceeding the limit for which security has been deposited at the rate specified by the state government, or such storage for the purpose of sale, import, or export shall make an application to the licensing authority in form XLVI ML1, and in cases of possession for bona fide use shall make an application in form ML2, molasses 2, for grant of license. Then 237. Disposal of application for issue of permit or license. On receipt of an application form ML1, the licensing authority shall, after due inquiry by an officer not below the rank of Inspector of Excise and on payment of fees as specified, may be determined by the state government from time to time, and on satisfaction that the grant of license is not detrimental to inputs or prohibition in any area of storage or possession as applied for, grant license in form ML3, and in the event the refusal to grant license, the licensing authority shall state the reasons thereof. So here there is no question arises because he has never applied for license. He has never applied. Now, for the purpose of, since he has never applied, without license, he was running his Budaku factory for 6 years without an application or making an application. On receipt an application in Form 2, the licensing authority, after due inquiry by an officer not below the rank of Inspector of Excise, and on satisfaction that the applicant follows the Indian Standard Institute formula or the formula approved by the Industry Department or Fishery and Animal Resources Development Department in cases of cattle feed or poultry feed manufacture, or the applicant has obtained small-scale industry certificate from the Industry Department or sales tax registration certificate from the Commercial Taxes Authority of Council. Then on the Spanish one, the fine he has not paid.
No, where have you decided or determined the fee? Where have you determined the license fees or applications?
That government has to decide from time to time. That we have indicated in the chart itself. How we have calculated the chart itself. Application fee.
Where is that?
Page 9 of my counter. Page 9 of my contact table is there.
No, that is on the basis of what?
The application fee, it is every year it is changing.
No. That you have placed in the counter, but on the basis of what? Where have you mentioned? Where have you determined this?
Then the determination is fixed by the government policy.
On their own? Where is that?
That notification, government.
No, that notification.
Notification, I think.
I have given that notification, my lord. In my rejoinder.
Oh, then rejoinder.
Rejoinder method. I have given one notification.
There is no dispute with regard to that petition application fee is that, 25,000. Subsequently, it is 36,000.
It's an excise policy, annual excise policy.
Excise policy to do.
What is that notification?
The rejoinder.
License fee, you have said.
Application fee and license fee. He has initially filed the case for excise duty, was charging excise duty, and this honorable court decided that no excise duty can be levied on this molasses. Therefore, that has been excluded, only application fee and license fee has been charged. No excise duty has been charged.
But and this, that page 18 of my rejoinder.
18.
When I'm looking at it, the tabulation that is given. You are coming under serial number 8, Roman 8.
Application fee in respect to
Out still units,
no, my lord. It is
or you are coming under 4.
my lord. That is 35,000. They say it is 35,000. Yes, ma'am. Application fee, that is. I come under that. I say, my lord, in my rejoinder, I have taken that.
The application fee cannot be charged.
Yes,
In the absence of any power.
yes.
That's true.
Even my lord, for that,
He's talking about all the license.
Yes.
He has not gone into the application.
license fee also, my lord, that also part is also missing from that rule 2. Rule 2 is the application, my lord.
Let us see, we have to create a dichotomy between the different provisions. Yes, sir.
No, so can you come to my reply to the application filed on behalf of the open number 2-3. Sorry, I filed a reply to the rejoinder what he has filed.
Oh, reply.
Because he has
Reply to a rejoinder.
he has got some new facts in that, therefore I have to reply along with provisions. of the-
What is that? Flag. There's not been incorporated.
That is there.
Price more than.
Not there. Or in physical copy, it is also. Not here. It is a rejoinder the change. So they have right here, I believe.
No, we have filed in the mail. Email.
Which matter?
That recent matter, my lord.
You know, 1528.
Ah,
1528. 1528.
Thanks.
Flag 30.
That is the regional.
Rejoinder.
Reply to regional.
it's not this. Again.
No, it is not here. Reply to rejoinder is not here, right? Where you find and when you find.
21/7. 21/7 I filed. Okay.
So how that is.
21/7.
Today is 23rd 7. So. Your office does not act in the face of a jet. Then how you expect the other officers to act at a jet pace? Because why?
Both expect of them.
reader. The reader is destroyed answer.
Paragraph 8, directly paragraph 8. Paragraph 7, so paragraph 7. The Odisha said that 2008 is a comprehensive legislation enacted to regulate.
Already you are arguing.
Yes, I argued that section 8, 9, 10 that are replacement.
That is also your place, 11, 14, 17, 18, manufacturing, storage, possession.
Yes.
Excise duty leviable.
My entire case is that section 2 to rule 234 clearly says that for the purpose of the license is required for the purpose of purchasing, keeping or utilizing.
Where is the provision for an application fees?
Application fee is there, no?
Where is the
45,
provision?
section 45.
45.
Section 45.
Yours? Yours size, that is the closer, what's the rules, sorry. What is the,
Fees for terms and conditions and duration of
every license permit
every
or pass?
license permit or pass under this act shall be granted on payment of such fees.
That is the license fees, permit fees,
Yes,
pass fees, then
pass fee. The license fee, permit,
where is the application fees?
an application fee.
Is
Then-
yours?
Then also turn to rule 234.
Yes. 234.
Possession, storage, sale, and use of.
Sir, it requires a license fee, a license to be there.
Application.
You can
application.
put a license fee. He is also talking about application fee. Though he says sub-rule 2 does not talk about either license fee or application fee, but let us see. License fee one keep aside. Where is the provision for application? Where is the power?
Has got the power.
Forgot it.
Section 9210. Section 90.
Is regulating the time, place, and manner of the payment of the duty.
Yes.
What are the different provisions there? So I be inviting your attention. Where is the provision for application fees?
The section 9210 is that it authorizes the government to regulate the manner of payment of duties and fees. Then
Where?
92, 90, Roman within bracket 2, then
Number 10.
Yes.
This is regulating the time,
Yes.
place, and manner of payment of duty.
Yes, duties and fees. Then 92.
Or fees under different provision of the Act. Where is the provision of the Act? We are asking.
Yes.
What provision of the Act permits the fees? Which is the fee? Does it include application fee? We are asking you.
Yes.
Where is that, sir?
Yes.
That's right. Yes, sir.
Can-
Come ready tomorrow in the first half. Clear it, because we have a full board today.
State, the lottery winner have already deposited it.
Okay, first up, my.
Interest. Additional state will get the,
In abstract 27, we have also appeared and filed a petition of.
No, I am also appealing 27. No, can you take up please? No, because we have deposited all the fees for this month, we are not.